You're tuned in to Agriculture Today, and we start our Wednesday show talking about the Horse Protection Act with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Thanks for having me, Shelby.
Roger, talking about the Horse Protection Act and new regulation that will be coming into effect February 1st. But first, backtracking back to 1970, and what was the Horse Protection Act?
Well, it was intended to end the inhumane practice by owners and trainers and exhibitors of deliberately making sore the feet of a Tennessee walking horse. So it was restricted to the Tennessee walking horse aspect of the equine industry. And those are the type of horses that you'll see in parades and shows. They're characterized by the high step of their forelegs, so they really pop them up high. And it looks really cool on TV or when you're there watching it. But the problem that Congress was trying to legislate out of existence was the practice of trainers of those horses, soring them, either by applying chemicals or by placing some type of painful collar around the top of the horse's hoof that would cause the animal to step up in that pronounced manner. So it really wasn't training Congress was fearful of and was being told at the time, that some of that's not happening just because of good training. That's happening because there's pain associated with the horse putting pressure on its hoof, and so it pops it up real high. And so the Congress outlawed in the Horse Protection Act those procedures and made it an inhumane practice if it was done in interstate commerce. And, of course, that triggers some pretty severe penalties. And then they made this provisions even stronger in 1976. So it doesn't prohibit, so to speak, the soring of horses, but it does prohibit a sored horse from being entered into horse shows, exhibitions, sales, auctions, and moving in interstate commerce, or substantially affecting commerce. That's the legal lingo there on that one. And they extended it in 1976 to intrastate commerce inside a single state. So, it doesn't outlaw the practice, but if you do it, you're going to lose a lot of value as to why you have a Tennessee walking horse. So you're going to be disincentivized from doing it.
Roger, what change are we seeing then here in less than a month?
Well, starting February 1, USDA and their sub-agencies have some new rules that are going to take effect, and these actually came down May 8 of 2024, so we know they've been out there a while, but now we're getting close to the effective date of these rules. And these are the result of some animal activists that are wanting more regulation of the Tennessee walking horse industry and expanding the definition of soring to encompass as much of the entire horse industry as possible. So now we're starting to move beyond just Tennessee walking horses to all types of horses, and that's despite the compliance rate historically with the Horse Protection Act over 90%. So there's really not much of a problem here, and certainly not the level of problems that would warrant expansion of this beyond just simply Tennessee walking horses.
And Roger, you wrote a blog article on this, and within this article you have quite a few bullet points of significant changes, and one of those bullet points, event management responsibilities, and what changes have happened there.
Right. If you're a horse event manager, then you have to notice, under these rules, if they take effect as scheduled on February 1, you're going to have to notify the USDA's APHIS, their Animal and Plant Health Inspection Service, at least 30 days before the event, indicating whether you have appointed a USDA horse protection inspector or requested an APHIS veterinary medical officer to conduct inspections. So now you got to have everything inspected. You're going to have to notify USDA that, you've got qualified people lined up to do that. You have to notify them 30 days before your event. And then any event update has to be provided 15 days in advance, and the managers then would have to report any violations to the regional director of APHIS within 5 days after the event concludes. And you also have to identify, as the manager of the event, the identity of each horse entered at a show, exhibition, sale, or auction, and maintain all horse show and exhibition records for 90 days and make those records available to inspectors. So those responsibilities fall on event managers.
What are qualified personnel for the horse protection inspector or APHIS veterinary medical officer?
Well, they have to be licensed veterinarians or individuals with extensive equine experience, and they're going to be responsible for doing the inspections at events. And the problem, the associated, as I see it, problem with this is at the same time all these new rules are coming into place and you've got to have your veterinarians inspect these horses and so forth, they're discontinuing under these rules what's known as the Designated Qualified Person Program. and the role of horse industry organizations in inspections. That's all going to be discontinued. So only your APHIS, veterinary medical officers, and HPIs are going to be able, your horse protection inspectors are going to be able to conduct inspections. So that's going to thin the available pool of inspectors at a time when you have more requirements and time frames put in place. I think it's going to be pretty tough, at least out of the gate on this thing. There'll probably be bottlenecks in the system.
Can an event manager not hire an inspector?
Well, no. If you do that, you're going to be in violation of the law, but you've got to get those inspection protocols lined up in advance.
And Roger, there's also been a ban on some additional equipment with this HPA regulation.
That's right. The use of what are called action devices and pads by Tennessee walking horses and racking horses during competition is prohibited. Now, you can still use weighted shoes and bands. Those are permitted, but action devices and certain types of pads. So they're controlling and eliminating certain types of other devices.
And there are also some more things that have been prohibited also.
Yeah, all substances applied to the extremities above the hoof of a Tennessee walking horse or racking horses during competition, those are banned. That includes lubricants, anything you would do to prevent masking of soring so that it can't be seen. Those substances are banned. What
if a horse just looks like it's had previous scarring?
Well, they are modifying the SCAR rule, and there's different inspection criteria. And so the revised SCAR rule provides a list of dermatologic conditions that indicates soring. And so inspectors are going to have to use their judgment to determine if a horse exhibits signs of soring based on those conditions. So a lot of judgment calls are going to come into play on that.
Within your blog article, there's also a list of things to make horse owners aware of, and one of the things in that list, ill-fitting equipment.
Yeah, anything that can make a horse sore, lame, or irritated, those items are prohibited. Sore muscles from a focused training session or a small rub from an incorrectly fitted bell boot could be equated to intentional soring. And I think that's something that all horse owners are going to have to pay close attention to once these rules go into effect.
Also, really paying close attention to what substances they are putting on their horse?
Right. Any substance that could make a horse sore or have any type of inflammatory reaction is prohibited, and that includes therapeutic liniment, which it's kind of surprising that's in the rule, but it is. And you can't use any substances on the limbs of a horse, including skin or hair conditioners or fly spray.
And for these rules, they include more than just the horse owners.
Right. They're not the only ones that are liable. Any participant with horses is subject to liability, including agents and haulers and trainers and vendors and supporters and sponsors. So really, really broad reach.
What are some other things that horse owners might need to have for inspectors when it comes to them looking at their horse?
Well, any information requested has to be provided to inspectors on demand. And the inspections, keep in mind, this can be pretty broad because those inspections are not limited to simply visual inspections of a horse and review of all records or physical exam of a horse. It includes such things as touching and rubbing and palpating and observation of vital signs and use of diagnostic devices. So those horse inspections are really, really broad. And they can actually remove shoes or any other equipment, substance, or any, as the reg says, paraphernalia from the horse when deemed necessary to conduct the inspection. So you really have to open up your business to everything and anything an inspector wants, and then they have pretty much unmeasured, unlimited authority to do what they want to do during the inspection.
Can the inspector then detain a horse?
Well, they can detain it for 24 hours. So there is a rule that allows a detainment period, and that's for a full day.
Is there ever a time where a horse might need to be re-inspected then?
There is. Any horse that wins first place in a class is required to be re-inspected. That's not optional. That is mandatory.
What's the overall big picture that you'd like to share with our listeners when it comes to this Horse Protection Act?
Well, it expands to all horses. It includes all horse events by all horse breeds, and so the reach would also extend into shows involving horses, for example, from local 4-H play days all the way to international competitions. And so you've got a dramatic increase of the scope of the Horse Protection Act. Same time again, the USDA is reducing the number of possible inspectors, so you're going to have a shortage of qualified inspectors. So under the revised rule, APHIS really has a lot more control and responsibility for inspections, for training, employing inspectors who have to be licensed veterinarians, as I said, or or veterinary technicians. So a lot more government control over horse events.
Anything you're keeping your eye on as we move forward with the Horse Protection Act?
Well, always when the government expands its reach, it tends to expand it even more. So we'll see where this goes. I know the horse industry, the equine industry in general, is very opposed to these rules, and they're trying to get them eliminated before they take place. Of course, we have a new administration coming in. We'll see what happens in the next few months.
Roger, I appreciate you taking the time to join us today.
Thank you, Shelby.
That was K-State and Washburn law professor Roger McEowen. If you'd like to read more on this topic, I will link his blog article in today's show notes on agtoday.net, or you can also find it by going to agmanager.info.